Hello, everyone. My name is John Rapp, and I'm one of the senior litigators at Harris Bricken. Welcome to the webinar today. This will be just 1 hour. You'll be able to submit questions. Some of you have done so already. You can submit them also during the webinar, and we will answer what we can now. We will answer the others later. You'll leave today with hopefully answers to your questions, an understanding of what ADR is. ADR is an acronym for Alternative Dispute Resolution, basically any kind of resolution outside of court. You'll have a document called the Top 12 Tips, and we've added an extra one for you that you can take with you, and whether you contact us again or not, you'll have these tips that can help you make better decisions about conflict resolution. We also offer free initial consultations for about 20 minutes usually to decide whether we can help you. And if you have questions today, please let us know. We'd like to help you. Finally, many of you are already members of the Cannabis Law blog, Canna Law blog that we run, one of the more popular blogs in the nation, actually, legal blogs. So please at least consider signing up for that if you haven't already. One last kind of ground rule, we have a lot of different levels of people on the phone today. Some people know very little about this topic. Some people know a lot about this topic. So hopefully you'll enjoy most of the seminar, but probably all of you at one point might wish that we'd move on to a different point. That's just one of the problems that you always run into with a webinar with a big registration like we have today. So again, feel free to send us any questions that you have, and we will plan to get right back to you. Alternative dispute resolution doesn't become an issue until you either have or think you will have some form of conflict. The first distinction I always try to get my clients to think about is how much is at issue. If you're fighting over $5,000, it's going to be very expensive to go to court to try to deal with that. If you're fighting over $5 million, then it's worth going to court, but it may also be worth going into arbitration, mediation, private negotiation. We'll talk more about all those things here today. But as I say sometimes to my client, the word principle, fighting over principle with an E, can very often become fighting over principal with an A. In other words, it costs money to fight over principle. So as I know at least one of our speakers will be talking about today, it's very important to make these business decisions as opposed to emotional decisions that we're all want to make when we're upset and under pressure. Arbitration in particular has become very popular worldwide. I worked overseas for several years, and their court systems very often are unreliable, can be expensive. The US is considered even more expensive than most jurisdictions. So there's really been a solid movement toward alternative dispute resolution pretty much around the world. Someone had asked in one of the questions if we get into cultural issues. I don't think we'll go deeply in it today, but suffice it to say that most of what we're talking about today cuts across cultures. The forms of ADR that I'll be talking about generally here, and then Jesse and Jihi will talk about in more detail, apply in most disputes, certainly across this country. And I think you'll also understand more why that is when they get into the details of how to make alternative dispute resolution work for you. I'd like to talk about one form of alternative dispute resolution that's easy to forget about, and that is demand letters. I like to think of litigation in phases, and unless you have an unlimited budget, which none of us do, it's important to try to ratchet up your leverage, the dispute, slowly if you can, to give a chance for some resolution to come about. So for example, I find clients often have tried some negotiation on their own when they come to see a lawyer. At that point, I say, well, we have to do a conflicts check and need to know more about your dispute, but perhaps we can make a phone call. Sometimes that works. Doesn't always work, but I made a call once for somebody and they got a $10,000 check the next day. Unfortunately, I didn't have on a contingency though, so I ended up just getting lunch. But sometimes minimum force can help, and of course, it's much more cost effective. Once your lawyer takes on your case, you can consider sending a short demand letter, something that just kind of outlines your position very briefly, gives a deadline. That can work. Often it doesn't work because by the time the parties have gotten to an attorney, the dispute is really well underway. Probably the most common device for avoiding litigation at the very beginning is the detailed demand letter, where you basically put together your case in the form of a letter. It can be quite a long letter and it may have voluminous attachments, but it's still going to be easier at that point to make some progress before you end up spending all the money to go to court. At that point, if it still doesn't work, you can send the other side a draft complaint. If that doesn't work, you can file and serve an actual complaint, and then you're off to the races. But before you go that last step, what we're talking about today is the ability to divert your case into some form of alternative dispute resolution, such as arbitration, which GE will talk about, and mediation, which Jesse will talk about in more detail. One thing we're not talking about today is so-called quasi-judicial litigation. So for example, in front of the administrative agencies, such as the LCB in Washington or the OLCC in Oregon. Again, those are important bodies. It's an important type of litigation. We've actually had quite recently another webinar specifically on administrative litigation, which you can find on our website and which I highly recommend. The basic advantage to ADR, both mediation and arbitration, is the ability to control the process. In mediation, you're basically just negotiating with some help. With arbitration, you're asking a third party, a neutral, typically an experienced lawyer, or potentially you could even hire an experienced non-lawyer who knows an awful lot about cannabis. As we all know, in this still nascent industry, it's sometimes hard to find people who really know the ins and outs of the cannabis business. Increasingly, there are lawyers and ex-judges, however, who have that experience. And the main difference between mediation and arbitration is that arbitration is binding. One of the big disadvantages of arbitration is the lack of any kind of particularly relevant appeal. It's just extraordinarily hard to appeal. And again, Jihi will go into that in more detail, give us some very recent background on an arbitration she and I were involved in. We can't give details, but we can give examples. And that's another thing to remember, that people, it's very easy to forget. Arbitration and mediation are confidential. And particularly in a small industry like ours, that can be very important to keep your disputes out of the headlines, as they say. Someone asked us in the form of a question when they registered. I'll read it here. It's a rather long phrase. What is the most common cannabis-related litigation backup causing issue? Now, I'm not sure what all that means, but I can tell you two very regular disputes that tend to come to us. One are issues involving the regulatory bodies. And as I mentioned, that was the subject of a prior webinar. And the other issue that comes up a lot, and you'll hear oblique references today to it, is that a lot of these disputes boil down to disputes among the business partners. In other words, at one point, everybody was happy. They got married. They forgot to draft a prenup, which you're going to hear again about more today. And by that, I mean just LLC documents, shareholder agreements, articles of incorporation, joint ventures, memoranda of understanding, of intent. All those things, I can tell you the three of us have seen many times in disputes that have none of those documents. Similarly, when you have potential employee disputes, there are time-honored ways to handle those before you ever reach the dispute level. There are policy manuals, employee handbooks, non-competes, non-disclosure agreements, and maybe most important of all, alternative dispute resolution agreements, so that disputes within your company are reduced and you've got ways to handle them short of filing expensive lawsuits. Excuse me. So make sure to try to predict expect that you will have disputes both with your suppliers and your customers and with your own employees. Secondly, make sure that you have those kinds of documents, employee manuals, NDAs, ADR clauses, written by an experienced attorney. And best is not just an experienced attorney, period, but an experienced cannabis attorney can be a big help, because again, these issues do tend to recur. Consider putting an ADR clause in every one of your contracts so that at least you have the option, well, it's not even the option, you have the alternative of not having to go to court. And those should be written, at least in the first instance, by an attorney, because I've seen a lot of them that have things like non-binding mediation and other strange creatures that actually don't exist in the law. Or someone forgets to put in a choice of law clause, or someone forgets to put in a venue clause. So you know you have to arbitrate, but you have no idea where. Those are all things that Jihi will talk about in more detail. And finally, I'll give you my own, kind of to wrap this up, section from an overview. I do believe that there's a lot to be said for a phased approach, so that you go in first with a demand, then a more detailed demand, then a complaint, before you start ramping up into discovery of documents and depositions and all the things that many of you know make American lawsuits among the most expensive, time-consuming, and unpredictable in the world. So I'll look for your questions on the chat room or afterwards, or the chat question function here and go to webinar or afterwards. But with that, I'd like to turn it over to Jesse Mondry. By the way, I forgot to mention earlier, between Jesse, Jihi, and I, we're admitted in Washington, Oregon, Minnesota, and New York. And in the firm, we have people admitted in many other states. So if we can help you anywhere, feel free to give us a call. Jesse, take it away.
Sure, thank you very much, John. As John said, my name is Jesse Mondry. I'm here at Harris Sliwoski's Portland office, along with G, who is also licensed in California. So we pretty much got the West Coast covered, as well as portions of the East Coast and the Midwest. So I'm going to focus here on mediation and kind of on three sort of broad topics. What is mediation? Why and when would you mediate? And what are some strategies for preparing for mediation and strategies when you're actually at a mediation? So let's start with the first topic. What is mediation? John kind of explained it, but it's essentially a non-binding form of alternative dispute resolution. So what it really is it's essentially a negotiation between the parties that is moderated by a third party. That's the mediator. Now, typically how this works is one or the other side of a dispute is going to reach out and ask if you want to mediate, or perhaps your contract requires you to mediate. So the parties will negotiate and to select a mediator, and usually negotiate that who's going to share the costs of the mediation. Typically those are split between the parties. Most mediators then ask each side to prepare a mediation statement. These are usually confidential. And a mediation statement is in the form of a letter, or it can be in the form of a brief. But essentially what the mediator wants you to do, and what you're going to want to do, is lay out the factual background of your case, provide some of the legal analysis of the claims, that is to say, why you've got a meritorious defense or a meritorious claim for money damages. And you're going to want to talk about the settlement negotiations to date, if there have been any, what you really think is a realistic settlement value for this case. And you're going to want to provide the mediator key documents. It could be contracts, it could be that smoking gun email, or things like that. We don't want to overwhelm the mediator, but we want to give that person enough information so when they come in, they can actually really help the parties see if they can reach a resolution. A couple other things. This just came up with some clients the other day. They said they don't want to go to mediation because they don't think they can sit in the same room as the other parties for 8 hours and hash something out. And that's typically not how any mediation works. Typically, in any mediation I've ever done, each party's in their own separate room. The mediator will spend time with each of the parties, talking to them about the case, talking about the strengths and weaknesses, and essentially conveying settlement offers and negotiations between the parties. And so you can go a whole day, and I've done this for days on end, never even the other party or the other attorneys. So mediation isn't something typically where everybody sits down in a big room and we're really going to negotiate this. The idea is to keep everybody separate, but give everybody a confidential third party to talk to about the strengths and weaknesses of their case, and a way to evaluate the case and see if they can reach a settlement. So that would bring us then to that next topic, the next sort of big headline, which is why would you mediate? There's a few ways you get to mediation. If a lawsuit has actually been commenced, the local rules may require you to mediate. That's certainly the case here in Oregon. There are particular kinds of lawsuits, or if you want to push your trial out past a certain deadline, the court is going to require you to mediate. And that doesn't mean mediating before the judge. It means you have to go out and find your own, mediator, and you guys got to make an attempt to try to sort of settle the dispute. So the second way, and I think John mentioned this, is that your contract may require mediation. And this is something you see quite often in commercial contracts, sometimes in cannabis contracts, which that phased approach that John is talking about might require first mediation and then arbitration. And you see this in anything from construction to cannabis to you name it. So, those are kind of the paths to mediation. And then in terms of the when you're going to mediate, if the lawsuit has been filed and the court requires it, that's probably going to be by rule. It's going to be set before a certain deadline. If your contract requires it, mediation is usually going to be the first step. You're not going to be able to go to arbitration and then mediate, obviously. But the other part of the win of it is that, and this depends on the circumstances, I think, that you find yourself. There are some certain kinds of cases, and particularly I recommend this when the dollar figure in the dispute is not in that $5 million range, but maybe it's in that $500,000 range. After the demand letter, but before you file a lawsuit, you're going to want to try to mediate this case and see if you can't resolve it. This might involve getting a tolling agreement if you've got statute of limitations issues, but a big part of that is really reaching out to the other party or their opposing counsel, engaging whether there's actually interest in a mediation and whether it could be fruitful. And a lot of the times, the dispute between the parties, and you'll know this best, it's not going to be fruitful to try to mediate before you file a lawsuit. So in that case, you might want to go right to arbitration or to mediation. In other cases, you might follow a demand letter, just as John said, right by trying to mediate the dispute. That doesn't work out, then you can go to arbitration. And a key part of it, as John said, is that mediation is typically confidential. And it's confidential in this important respect, is that the mediator will keep everything you tell the mediator confidential and not disclose it to the other side during the mediation without your express permission. So this allows you to really be frank with the mediator. And I think that's what I would say is the turn to that next part that I'd like to talk about, which is the sort of strategies for a successful mediation. And I think the first one I've touched on is that, you want to have your attorney confer frankly with the opposing counsel whether mediation is worth it, whether it's worth the time and expense. Mediation is certainly less expensive than arbitration, certainly less expensive than a litigation. But if you've got a case where the other side is offering you a nuisance value settlement, or that the other side doesn't have any money, it may not be worth going to spend $5,000 or $10,000 on a mediation if you're not going to get anywhere. And and that's something you have to work out, I think, with your attorney as you go along. I think the second part is select a mediator carefully. We've all had experiences here where we walk into a mediation and we think this is going to go great, but the mediator, for whatever reason, maybe they don't prepare the same way, maybe their style is a little bit different, and it's not something that's that really doesn't get the parties to come together. Maybe they're sort of too soft or too easy. Maybe they're too hard and they're pushing everybody apart and nobody really wants to talk. But I think all of us here have those sort of, war stories to do that. So I think, one of the ways to investigate who you want as a mediator, and your attorneys will know this, is you're going to want to form a list with the other side. Typically, you're going to do some due diligence, talk to people, find out, who's good. And we've put together sort of a short list of some people we like, and we could certainly provide that at the end of the call or something like that for here in Oregon and Washington. You want to find somebody, I think, who's got some background in the cannabis industry, but increasingly that's not what's most critical. And that's because what we're really doing now are business disputes, that people who have a good commercial background and who can understand how contracts work, how common contracts work, how those clauses work, they can handle this, even though there might be a cannabis overlay on top of it, whether that's hemp, whether that's CBD, or whether that's recreational marijuana, depending on your jurisdiction. I think the third point is to really spend some time on your mediation statement. A lot of the times we'll have clients who they want to put a lot of work into it, maybe to save costs, but it's really a good time to spend some of that money up front, because what you're going to find out is you're going to learn about the strengths of your case. More importantly, you're going to learn about the weaknesses of your case. What are the real tough spots on you? Because to be sure, if you've got a mediator who's worth their salt, once you get in there, the mediator is going to find those weak spots on your case, and they're going to push you on that. And that kind of brings me to the next point, which is that a mediation, typically is 1 day, and you need to be prepared to wait. That's because the mediator is going to go from room to room and essentially, sort of beat down everybody to try to get them to come to a resolution. So, you might sit in a room for 2 or 3 hours and wait for the mediator who comes by for 15 minutes. That mediator is going to focus on the weakness of your case, try to get you to, increase increase what you're willing to pay or decrease what you're asking for. And they're really going to try to focus on those points of your case. So having a good mediation statement that really sets forth, the facts and the law in an accurate manner is really helpful, because it provides you with a lot of information. And the second part is that you can really develop trust with the mediator, so they know that you're the party they can go to when they want to find out what's the real story here, what are the real facts here. You've done the work, you've put in the background, and that's the same way you'd want to do it in an arbitration litigation. I'll try to wrap things up here. Just a couple more, I think, thoughts I have is that, and this, I tell you this is, don't make a final offer unless it really is your final offer. And I'll say this, I was recently in a fairly complex mediation that involved, I think, 6 parties, and it was a cannabis dispute. And we had a client who, after a few hours, decided to put out a final offer. And as soon as that was done, the mediation was over, really, because if the other side wasn't going to accept that, accept that offer, well then that was it. And now what that's done is push us into litigation where we're going to do depositions, and we're going to have to spend a lot of money because we've sort of made a final offer. Now, if that's not really your final offer, the other side, now you're sort of establishing yourself as you're not trustworthy in terms of negotiation. And when you say it's really your best and final, it's not really your best and final. So you want to be careful before making that, before making offers like that. I think another part too is to, don't get frustrated and walk out. That gets tempting sometimes to do that. You're going to be, but don't get frustrated and walk out, unless you're in a circumstance where you think that might be a good tactic. But I'll tell you what, if you think that that's your case, that should be something you've planned and decided ahead of time, not something you decide at 2:30 in the afternoon because you might want to catch a flight home or because you think that this is really going to scare the other side. That's something you should think through and talk through with your lawyer if you're going to try sort of a final offer and a walkout strategy. So one last thing, I think when we get to, the goal of mediation is settlement, right? The goal of mediation is to avoid the expense of litigation, avoid the expense of arbitration. So when you walk in there and you're thinking about dollar values, that's what most people are thinking about. Think about other terms of a settlement agreement. Have a short list with you so that when the mediator's typically going to have you go around and sign something. You say, all right, we've all got agreement on these terms. Have a list with you of other terms that are not just the dollar amount that you're going to want in there. This might be confidentiality provisions, attorney's fees, like a loser pays for somebody who breaches a settlement agreement, non-disclosure agreements, non-disparagement agreements. So there could be a lot of sort of different terms. You might iron the details out later, but at least you can kind of get those points down and those are agreed to, because you don't want to blow up a settlement. Later you can't come to come to agreement on some of the lesser terms, I guess I'd say. So I guess with that, I think, so if your mediation does work out, you've got that agreement. If your mediation doesn't work out, then you might be off to arbitration. And so with that, I'll turn things over to Jihi. Thank you.
If I could real quickly, Jesse, Jihi, do you mind if I answer one of the questions on the feed first?
No, go ahead.
So this relates to mediation. The question is, have you ever been involved in a partnership dispute where a receiver was appointed to run the business prior to the mediation? When would you advise the appointment of a receiver? So we'll come to the second question second, but the first question, the sequence doesn't quite work like that, because if you're going to get a receiver appointed, you have to go to court. So you might, the other side may dislike the receiver enough that they then want to go into mediation, but that sequence is not possible unless you've agreed to it in advance. As to when would you advise the appointment of a receiver, that's a much bigger question that we probably should have another webinar on someday, maybe someday soon, and we'll invite you. But this relates to both to disputes in general, and to cannabis disputes in particular. So the most important kind of receiver that you've probably heard of is a bankruptcy trustee, and federal, and bankruptcy is only federal. So at this point, the law is pretty complicated, but in general, you cannot get bankruptcy protection in cannabis cases. I believe I'm correct on that, at least most of the time. A receiver is a similar kind of person, but a state court appointed. And generally, you should get a receiver appointed whenever you can't get along. That's what receivers are for, to have a neutral person come in and run your business until your dispute is resolved. And with that, I'll turn it over to Jihi.
Thanks, John, and thanks, Jesse. My name is Jihi An. I'm also in the Portland office with Jesse, and I'm currently licensed in California and Oregon. Washington is pending. So like Jesse said, we really do have the entire West Coast covered with our firm, and we have other states in the Midwest and the East that we also have experience in. So before I get into the details of how you might find yourself in an arbitration or how it generally proceeds and my tips for, streamlining or making that as most efficient as possible, I kind of want to go back and distinguish what an arbitration really is. Because in my experience, I've actually been pretty surprised that the attorneys don't really know what the difference is between an arbitration and a trial, or an arbitration and a mediation. And John and Jesse both touched on this a little bit, but an arbitration is certainly different from a mediation because they're actually completely different processes with two completely different goals. And like John said in the beginning, arbitration is different from mediation in that your arbitrator or panel of arbitrators, as we'll talk about later, actually have authority to make a decision about your dispute, whereas mediation involves getting the parties to try to come to a settlement before they have to engage in any further litigation or arbitration proceeding. Generally, I like to loosely think of arbitration kind of as a private trial. The parties will agree on one or more neutral third parties or arbitrators to make a decision about their dispute after they present evidence and potentially present arguments. There's usually a hearing where attorneys will make opening statements and present evidence. They'll examine and cross-examine witnesses. So in that way, it's very similar to a trial proceeding that you might find in court. Compared to traditional trials, though, arbitration is usually much less formal and can be completed much more quickly, which is kind of the benefit to engaging in an arbitration as opposed to a court case. Getting into the timeline of things, as John kind of alluded to before, the first step in an arbitration process really takes place long before anyone is actually involved in an arbitration. And that first step is when you're drafting your arbitration clause to be included in your contract or whatever agreement that you're preparing. It's really important that you and your attorney consider, your industry and the most common disputes that happen within that industry, because the arbitration clause should include the basis for, and the scope, and the procedure of the arbitration. I know John also alluded to this before, but in my experience in the cannabis industry, I have found that most of my disputes I'm litigating involve LLC member disputes or breach of contract actions. So those are the kinds of things that you should be thinking about and looking out for when you're drafting these type of ADR provisions. It's also important to think about cost considerations when drafting these clauses. So for example, it's helpful to identify the number of arbitrators, whether one or a panel of 3 will determine the dispute that could potentially arise. Obviously, a single person panel is going to be less expensive than a 3-person panel. And scheduling also can become more of an issue when you have multiple arbitrators. But there can be a real benefit to having a multi-person panel if, for example, your dispute is really complex and it requires expertise in several areas of the law. So then you might really want a multi-person panel because there's the opportunity to have people with different areas of expertise. Finally, another thing that you should consider for your arbitration clauses or any ADR clause is to include the type of arbitration award to be rendered and whether you want a written decision or just a decision only. We can kind of touch on this further down the line, but after an arbitration process has completed, the arbitrator will issue an award, and sometimes they can, essentially include a brief that summarizes their findings of fact and law. And sometimes it can be a one-page award where it just says, the claimant wins or the claimant loses. I've generally found that awards that contain reasoning may make it more likely for one party to challenge the award. So that's another consideration that should be taken into account. I would say after you kind of make sure that your arbitration provision is drafted, another cost consideration to think about is the best forum or location for your potential arbitration. So I have experience with really great national services like the AAA, which stands for the American Arbitration Association, and JAMS that have rosters of really reputable arbitrators, but they can be quite formal and usually cost more. It's really could be to your benefit to research local options for arbitration services. So in Portland, the arbitration service of Portland is really great. It tends to be more flexible and it's been cheaper for my clients than engaging in a national service. So fast forwarding now, let's say a dispute has arisen and the arbitration clause you drafted many months or years ago is now coming into play. The next step in the process is initiating or responding to the arbitration claim and then picking your arbitrator or panel of arbitrators. Jesse kind of touched on this with the importance of selecting a proper mediator, and that absolutely applies here also. It's really important to conduct due diligence on the list of potential arbitrators in order to determine their background, their experience, and their tendencies in handling arbitrations that relate to your industry. You and your attorney could conduct internet investigations via LinkedIn, Google, and other various types of professional websites that exist out there. Depending on the jurisdiction, you can also seek out publicly rendered awards that might be accessible by your attorney, because reviewing past awards can really provide you and your attorney with a lot of insight on the arbitrator's experience and whether the arbitrator tends to lean towards the claimant or the respondent in a particular type of dispute. It's also important to investigate the reputation and effectiveness of your potential arbitrator. So, generally speaking, I think the best way is to conduct or is to have your attorney contact other attorneys who have had arbitrations with the proposed arbitrator. And contacting those attorneys can illuminate whether potential arbitrators have knowledge about the law, they have special insight into rules of the forum. Counsel can usually provide a lot of information about whether the arbitrator will allow the parties to really control the process and be flexible, or if they won't allow too many deviations from the rules, which might be what you want or it might not be.
G, would you mind if I added something a little bit to that?
Sure.
Sure. So just on this issue about all the options you have with ADR, which are really quite wonderful. I mean, court is basically one size fits all. This is make up the size you want. The key distinction, though, is that most of these things have to be agreed in advance. So, for example, one of the questions we just got about limiting depositions and discovery, yes, you do have to do that in advance. Some of that can be done in the arbitration service, and some of the arbitration service have rules about presumptive limits on depositions and things. But a lot of the services don't have that. And all of these things, if you want to know where you're going to be, how long it's going to take, what service is involved, limits on depositions, limits on the amount of days, you can agree to almost anything. And unfortunately, if you don't, it's pretty hard to go to arbitration afterwards. You can try, but a lot of times there's a lot of gamesmanship about not showing weakness. And if we propose arbitration, are we looking weak? All that kind of thing. So anyway, that's just a little bit more of a drill down given that particular question. Thank you for that question. Go ahead, Jihi.
Thanks. Yeah, I mean, streamlining the process, we can definitely talk about a little down the line, but I'll kind of go back. So my next tip kind of has to do with setting up your attorney for success in arbitration. And this kind of has to do with the timing or how quickly an arbitration process can go. In my experience, I haven't seen too many court cases go to trial within a year. But for arbitration, you know, I've seen them go to a hearing within 6 months to 1 year. So it's really a quick process, and you need to do what you can to help your attorneys prepare efficiently. Once an arbitration is initiated and the arbitrators are chosen, the best thing you can do as a client is provide the entire universe of documents and information to your attorney. Proper documentation of agreements, conversations, resolutions, things like that can go a really long way. And even if you think, you know, something might not be super relevant or super helpful, your attorney is really the person that should be making that call. Only after your attorneys have the entire universe of documents can they make an accurate assessment of the strengths and weaknesses of your case. And then this can help them make decisions on how to streamline the process, kind of like what John has just discussed, because ultimately you're not going to want to dispute or litigate facts that don't need to be litigated. Because arbitrations typically proceed faster than court cases, discovery of new documents or information down the line can also create really big kind of backups or hiccups. And so generally that should really be avoided. Once you and your attorneys have a good idea of how strong your case is, like I said, you can make those calls to streamline the process. So if there's a chronology of events that is not really disputed, then formally agree or stipulate to them. If there are undisputed facts, stipulate them. A lot of arbitration preparation and hearing time can be wasted on establishing facts that nobody's disputing. And in my personal experience, I've seen how this can really annoy your arbitrators. Your attorneys can also save you cost and time and probably some frustration by asking the arbitrator to require stipulations of like a basic factual chronology or all of the facts that are not in dispute. Kind of like what John said, there are a lot of ways to streamline the process. You can limit the number of depositions per side. You can limit the number of hours per deposition. You can, you know, agree to have no depositions at all. You can set a shorter time frame for discovery to be completed. Just be creative and make sure that you and your attorney are tailoring your particular arbitration to fit your needs and ensure that at the same time, your case is being properly developed. Obviously, kind of to that point, Even though we're talking about ways to streamline the discovery process, most arbitrations will require some level of discovery to develop the case. So, you know, it's great to be creative in those aspects too. In my recent arbitration, it was really great to consider options like public records requests or subpoenas, as long as they're done pretty early, because it can take weeks or months to get documents. If you're finding that the other side isn't willing to produce something, for example, like bank records, consider subpoenaing the bank. Even if you believe that you're entitled to these documents from the other side, oftentimes it's just more efficient and less expensive to subpoena the source directly than engage in this costly discovery battle, which arbitrators usually hate. My next tip has to do with expert witnesses. So arbitrators often hear cases across many different industries, and while they're experts in applying the facts to the law, they might not be experts, and they probably aren't experts in things like the OLCC rules or valuing your cannabis business. And that's why you need expert witnesses. Every technical fact ultimately has to be reduced to plain English, and every expert you present should be able to have, number one, a great grasp on your facts, and number two, they should be able to explain those facts or concepts to the arbitrator in a really simple and digestible manner. This is especially true when it comes to problems of math, because arbitrators are usually lawyers, and a lot of lawyers are not great at math. So expert witnesses really can help you explain how you got your numbers. And this is especially important when you're thinking about proving your damages, which is usually an element of most causes of action. So, you know, when an arbitrator is making their award, they need to be sure that your numbers and your calculations are based in reality. And it's not safe to assume that the arbitrator knows how you got to your $1 million or $2 million damage figure. Kind of as a precautionary tale, I've seen a situation where an arbitrator wasn't sure how, you know, a party got to their number. So that arbitrator, who we later found was not very good at math, tried to calculate the damages from scratch, and that ultimately didn't work out so well for them in the end. So my kind of last point on expert witnesses is to really get them retained and involved as early as possible, especially in this industry. The cannabis industry is still really small, it's still developing, and the great expert witnesses who understand it are pretty few and far in between. So I'm pretty confident that retaining and involving expert witnesses regularly, you know, at the very beginning of a case will yield lots of benefits down the road.
Thank you, Jihi. And on that last point too, I used to tell juries if I was good at math, I would have gone to medical school. But I don't know if that's true, but Jihi's absolutely right. There are some terrific arbitrators, extremely senior people who've done a lot of great arbitration, mediation, and they just are not that great with numbers. So having experts there who can give you, who can tell the arbitrator how they arrived at their numbers, at your numbers, can be a huge help. Well, between beforehand and, oh, I'm sorry, Jesse, do you want to say something?
Oh, yeah, I was going to respond to a question that had been posed earlier, but if you want to kind of go another direction, John, that's totally.
No, that's, I was about to turn to the questions. We've got quite a backlog now, so go ahead and pick off whichever ones you want, and same for you, Jesse, or Jihi.
Sure. I'll take the first. I think one of the ones that came along was somebody asking to explain the statute of what a statute of limitations is, and I think I got the question right. And so, very briefly, you know, one of the points of the judicial system is to get some sort of finality, whether it's through a judgment or some way. And one of the ways that we sort of get finality for disputes is by what's called the statute of limitations. What the statute of limitations does is say that you have so much time, or so many years typically, from the time the event occurred, let's say it's a breach of contract, you have to bring your lawsuit within so much time or that claim is going to be considered barred by the statute of limitations. So typically, every jurisdiction is different, but let's say a breach of fiduciary duty claim with between directors, you typically have something like a 3-year statute of limitations. What that means is if in January 1st of 2019, you discover that one of your directors has been siphoning off money into his private bank account and he's breaching his non-compete agreement because he's running another cannabis business, you need to bring that claim or bring that lawsuit within 3 years or you lose it. And that's essentially the short description of what a statute of limitation is.
Thanks, Jesse. Jihi, I'm just going to mention a couple of questions and answers here, and please dive in on anything either of you want to. On arbitration, and I will leave Jihi to maybe add a couple of details on this, but we had a question about whether or not arbitrators apply the law or whether they decide on the basis of, quote, substantial justice. Unfortunately, as with so many things in the law, the answer is both. The choice of law is normally decided in an ADR, in an arbitration clause. So for example, in a recent arbitration that we did, the law was Oregon. But the reason why people think that arbitrators apply only substantial justice and not the law is because there's almost no appeal. So the arbitrator can basically decide whatever they think is fair, or what some people call splitting the baby, which does happen often in arbitration, not all the time, maybe half the time. There is a right to appeal from an arbitration decision under both the federal and the state statutes, but it is so limited. You're talking about things like corruption or gross incompetence, that kind of thing. So essentially there is no appeal. So the bottom line for you is that you need to feel like your case is pretty good. And you shouldn't have ADR clauses in your contracts if you're going to take a lot of crazy positions, because you can drag things out a lot longer in court than you can in arbitration. And what we're trying to talk to you about here today is getting things resolved more quickly, less pain, less money, less publicity. So those are the kinds of things that you need to be thinking about if you're going to have an arbitration clause. Jihi, do you want to add anything to that?
I guess my primary thought on that question is, we have seen a lot of instances, like John said, where an arbitration attempts to split the baby between the parties. And if you kind of want to avoid that situation, the best thing we can tell you to do is make sure that your agreements or your documents are unambiguous and they're not really open to interpretation. Generally, all the setup that you do in the beginning is going to help you down the line. So it's a worthy investment to make sure that all the terms of your, all your written documents are clear. And so that avoids the possibility that the arbitrator might want to kind of appease both sides and be creative with his or her analysis. The more clear and unambiguous your documents are, the less chance they have to do that.
Yeah, one particular, oh, go ahead, Jesse, sorry.
I was going to add on, I think part of the question is these kind of issues a reason to avoid arbitration, or maybe not to put an arbitration clause in your contracts? And in my experience, and I think you could probably ask 6 people and get maybe 4 answers or something like that. My experience is that arbitrators typically do a pretty good job applying the law to the facts, and that I would not be inclined to advise my clients to don't put an arbitration clause in your contract because you're worried that at some point down the line you're going to get an arbitrator who might decide things a little more on notions of equity than on the rule of law. And I don't think that you see that as much. You don't really see that. I don't think I've seen that often. So I don't think that's a reason to avoid arbitration. It's so much less expensive and so much of a faster way to resolve disputes and litigation that I think it still has benefits outweigh its cons in that regard.
Well, and on that same point, I was about to say something similar. A lot of times these ADR clauses are combined with attorney's fees clauses. And I'm sure everyone on the line knows something, at least generally, about those. And what those do is most of the world actually has a loser pays system. The United States is the biggest exception. What this does is it changes to the so-called international rule, which means that if you win, you get your fees back. And that can be a big disincentive for the other side to want to fight. On the other hand, it's easy to make a claim against almost anyone. So if you feel like you don't want to be in a position where you have to pay the other side's fees for some crazy claim, or at least what you might view as a crazy claim, you just have to think twice about an attorney's fees clause. But in general, as Jesse said, 6 people, 4 opinions, I think most of the time an attorney's fees clause is a pretty good idea. As I hope you understand, I think we all think an ADR clause is usually a good idea. And the most important thing is to draft it well. And you'll see on the Canada Law blog that I actually wrote a short blog post about this exact issue, the scope of an ADR clause that we litigated last year successfully for one of our clients. That actually leads rather nicely, Jesse, into the whole issue about demand letters. And if you'd like to add a little detail, I just give the headline. The headline is the demand letter should give a preview of the pain to come. That if we can't resolve this the easy way, we are committed to solving this the hard way. So Jesse, tell us how to do that, since you just got a big payoff recently from a demand letter.
Yeah, I'll tell you what my tips or whatever, the way I think a demand letter should be written. I think one is, 3 things. One is avoid being overly bombastic, sort of threatening language. I think that it recognize that, think of everything that you send to the opposing side as potential evidence. Maybe it's a discovery motion, maybe it's at trial, maybe it's something, but you don't want to sort of, I don't like to sort of start out with a demand letter that, accuses the other side of just terrible and horrible things and, these things, even if that's what they've done. Keep it sort of, keep it restrained, keep it businesslike, keep it serious, but, can definitely convey that sort of, this is the pain that is to come if, sort of you want to ignore this letter or, just think this is going to go away. So I think that's good. I think the second thing is to be scrupulously accurate. When you recite the facts, don't overreach at all, because anything you overreach, the other side's lawyer is going to take you apart for that. You want the other side's lawyer to get that letter and say, well, are all these things true? You want the other side to say, that other opposing party to say, well, yeah, but, and now you've already sort of established that, your relationship, that you're not trying to sort of hide anything. You're not trying to pull any punches. You're scrupulously accurate. I think the third thing for a demand letter is to set a deadline, or set, what you expect to happen, and then to follow through. Because if you don't do that, you're establishing that as well. So that's part of the conversation I always have with my clients is, look, we can go with this demand letter, and we can go ahead, unless we're going to ask for $1 million, right? Let's say we're going to ask for $1 million. And well, what are we going to do if they just ignore this letter? And you have to explain, well, here are our options. Maybe our options are going to be mediation from the contract. Maybe we've got a binding ADR clause. Maybe we're going to have to file a lawsuit. But I think you want to think through and talk through, what your next step is, because depending on the size of the dispute, sort of your willingness to expend attorney's fees, that might, couch how you're going to sort of make that demand or that ask in there. We have some cases where that demand letter is going to take a softer approach, and we're essentially in the demand letter reaching out to see if they want to explore ADR. We might have another demand letter that says, pay us this much, by Friday, or we're going to court. And so you've got to kind of look at and evaluate, think the strengths and weaknesses of your case, and be willing to follow through with kind of what you've already planned out. So those are kind of my thoughts on demand.
Well, one thing to add to that, Jesse, just suffice it to say that the 3 of us together have seen an awful lot of disputes that, after both sides end up spending hundreds of thousands of dollars on attorney's fees, they end up settling for what they offered to settle with a year ago. And so in those cases, as they like to say, I kind of hate the sound of this, but the only ones who win are the lawyers, because it's not that we don't think what we offer is valuable, we do, but there really is no reason to end up fighting just because you're impatient, angry, they're more impatient, they're even angrier than you, and then you end up, having to produce hundreds or thousands of documents and have depositions. So it's really good to think about how you can ramp these things up slowly and find some lawyers who are committed to helping you find a cost-effective way to resolve and even win your dispute without court being the only option. Okay, one more question here. I'm going to take this really lightly because this is a super complicated area, but we had a couple of questions about bankruptcy, and one in particular about the possibility of using an assignment for the benefit of creditors to avoid bankruptcy. These are super complicated questions. At this point, as I understand it, there are not clear answers to these, but in general, the federal, the IRS, the federal courts, the bankruptcy courts, all decline in most cases to deal with cannabis disputes because of the federal illegality of cannabis. I'm intrigued by the idea of an assignment for the benefit of creditors. Send one of us an email and we'll see if we can get to the bottom of some of that for you. And yeah, like to help. Okay, let's see. Any other questions that are, oh, we're down to 4 minutes. Well, I guess I'd like to just make a little summary for you. Please go back through those top tips. We worked really hard on them, and they do distill an awful lot of what we have to offer. If you do need more help, obviously give us a call. Please sign up for the Canna Law blog. You won't regret it. With that, I guess I would leave it to Jesse and Jihi to, if you've got one final tip you'd like to give on each of your areas, I'll give you a minute to think about it. The one thing I would recommend that I do almost constantly in my cases is try to focus on what you're really fighting over. If it's $1 million, that's one thing. If it's a lot of hurt feelings and about $10,000 in damages, that's not going to work for you. And I find a lot of clients who have not really distinguished the business case from the personal emotional case before they decide to hurtle into litigation, which can be hideously expensive and take way too long. And in the end, what do you have? You have the right to present your case to a jury of 6 or 12 who are very unpredictable. And unlike arbitration, once you get a judgment in court, it is fully appealable. So now you get to wait another year for an appeal or more. So there's lots of reasons that ADR makes a lot of sense. I hope you've heard those reasons today, and we'd really like to help you in any way we can. Jesse, Jihi, any final thought?
I don't have much more to add. That would be about my summary as well. It's just, ADR is about settling a case, and so don't expect that you're going to get the full value of your claims or something like that. That you're going to have to compromise, and it's important to think about where the real breaking points are and to recognize the risks and the rewards possibly of going forward.
Yeah, I think the kind of final tip that I could offer is, if you find yourself in mediation or in arbitration, sometimes it's easy to forget that you are being involved in an official proceeding, because maybe you're in a conference room as opposed to a courtroom, and you're dealing with an attorney instead of a judge or a jury. And it's always good to err on the side of being overly professional, because arbitrators, mediators are watching everything, and ultimately unprofessional behavior is going to undermine your case. Same thing when you're kind of preparing motions or briefs. A lot of clients like to be very punchy and be sarcastic and use very bombastic language. And ultimately, most of those things are not really appreciated. And so I would just say, believe in your case, believe in your facts, and just set forth the best position that you can, and know that it's compelling and deserving of good results.
Great. Thank you, Jesse. Thank you, Jihi. And thanks to all of you for joining us today. We'll look forward to hearing from you. And if you have any feedback about the webinar itself, how we can make these even more interesting and exciting than they already are, send us a note. Thanks for your attention. Bye-bye.